So DWI third or more, now we're getting into some heavy stuff. Even in a super liberal, lenient, laid back county like Travis here in Austin, once you have been arrested for your third or more DWI, you're into felony territory. So your third DWI arrest is automatically a felony, no matter what happened in that DWI, no matter how severe or non-severe of a case it is. The fact that you have 2 prior DWIs on your record automatically enhances it to a felony. And the district attorney's office is going to take those seriously, less seriously than you would be treated in a more conservative county, like in Williamson County up in Georgetown, or Bell County in Killeen, Comal County in New Braunfels. But nevertheless, it's not going to be a walk in the park like it would on a misdemeanor. People do go to jail for felony DWIs, not as often as you would in the more conservative counties. And we usually can still keep our clients from doing serious jail time here in Travis County, even on a third DWI. But the amount of hoops and work you're going to have to put into getting out of serious jail time is exponentially higher. So we're talking probably multiple years on probation as opposed to 12 to 18 months like on a misdemeanor. We're talking serious community service hours, a big fine. You are definitely going to have some sort of alcohol monitor in your car for the entire time you're on probation, which is not fun. Blowing into a breathalyzer to get your car to start every time you need to drive somewhere can be a huge, huge pain in the ass. With that being said, we get a lot of these cases reduced from felonies down to misdemeanors. Over 50%, in fact, here in Travis County of our felony DWIs were able to get reduced down to misdemeanors. That has a lot to do with the really strong relationships we have with the prosecutors. It has a lot to do with our strategy in attacking these really aggressively for our clients. So we have our clients do a ton of things up front to make themselves look better in the eyes of the prosecutor. We have them do alcohol treatment. We have them take responsibility for the fact that this is now a pattern of behavior that they're willing to accept and do something about proactively and not wait for the judge to scold them or the prosecutor to force them to do it. And we call this a mitigation packet. We call it a good guy packet or a good gal packet. And we do all of this before we even start negotiating with the prosecutors so that we can walk into court. And on day one, when the prosecutor is asking us, where do we think this case is going to go? We set that packet down and we say, look at all the stuff that our wonderful client has done. He's taken responsibility for his actions. He's done this, that, and the other thing. He's gone to alcohol treatment and AA meetings, et cetera, et cetera, et cetera. And we blow the prosecutor's mind, and it really separates our client's name from the rest of the folks that these prosecutors are used to dealing with, which is, people who are denying responsibility and showing no remorse. That's how you get good results here in Travis County. So on a DWI third, it's even more important for us to take a look at the actual evidence, analyze it incredibly thoroughly before we have those first conversations with the prosecutor. Because you're looking at real jail time, you're looking at prison time, state pen time, and we want to be as sure as possible about the strength of the state's case, the strength of the defense's case, and what leverage we have. So if we look at this case and we realize that the state has serious problems with this, the blood test came back and it has anomalies in it that we know the state isn't going to be able to explain. So they're not going to be able to prove your blood alcohol content. Or we watch the video and you perform the field sobriety test really well, or the officer made mistakes in instructing you on the field sobriety tests. Or we watch the video of the officer pulling you over in the first place, and he claims that you were speeding, but we can tell on the odometer that you weren't speeding, et cetera, et cetera, et cetera. We want to find those holes in the state's case before we have that initial negotiation with them, because not only are we going to come to that negotiation with the good guy packet, showing all the things that you've already done to prove that you're taking this seriously and you're trying to take responsibility for the fact that this isn't your first rodeo. On top of that, which sets you apart from the crowd, we're also going to slam the state with, oh, and by the way, in case the good guy packet wasn't enough to convince you to go easy on my guy, you really don't want to force our hand and take this case to trial because you got some real problems. You don't want to face us in trial with a shitty case because we'll take you down. And that reputation precedes us. The prosecutors know that we're not bluffing when it comes to taking cases to trial. They know that we have analyzed the case better than even they will have at that point. And so they take our word for it. They're going to do their own due diligence and stuff, but it already puts them on the back foot, and they'll be much more easy to convince to go in a direction that we want them if not only do we have a bunch of things that our client has done proactively, but we've already started poking holes in their case. They're going to go on to easier fish. And that's how we get good deals.